Hello viewers, I am Dr. Harpreet Kaur from Army Institute of Law Mohali. Today we will be discussing the topic of reproductive rights of women. Reproductive rights occupy much important place in today's era as the act of reproduction and the ancillary processes associated with it, determining the position of women in the society. It is said that the task of strengthening the women in complete manner will not stand accomplished unless and until they are given power to control their bodies completely without any interference from any other person. It becomes essential to realize and channelize the reproductive right of women so that the concept of gender equality and women empowerment get established in our society in its true sense and spirit. The reproductive capacity of the female is portrayed in various ways under different theories relating to feminism. Few feminists believe that marriage is a legalized prostitution, while other feminists think that marriage is a rape. Women are always judged and looked down upon on the basis of their capacity to become pregnant and give birth to a child. In other words, it means that the females who are unable to bear the child are considered as barren and are ill-treated by the society at large. The question relating to the reproductive capacity of women, menstruation process, etc. are always decided under the paradise of reproductive right. Meaning of term reproductive right. In general term, reproductive right aim to pave way for establishment of such state where both the males and females are having freedom and liberation to decide about their reproductive choices freely. According to Merriam-Webster's Law Dictionary, the term reproductive rights include in it the authority of the female to decide whether she wants to become pregnant or not. The International Encyclopedia of the Social and Behavioral Science 2001, while talking about the reproductive rights, declares that reproductive rights include in the liberty of individual to make decision with regard to use of contraceptive method, abortion, childbirth, etc. Reproductive rights are part of human rights. While understanding the concept of the reproductive rights, it becomes essential to know the fact that reproductive rights contain in them certain fundamental rights which are part of human right as well. The reproductive health of the female can stay protected if there exists equality in every sphere between a man and a woman. In other words, in order to protect the reproductive rights of the women, it is important that the human rights are also protected. Human rights always focus attention on protecting the life and liberty of human beings and allowing them to lead a dignified life which is not reduced to bare animal existence. Reproductive rights can be claimed and exercised in a healthy manner if life and liberty of females is also protected in complete manner. In other words, it signifies the duty on the part of the state to establish such a social order where law is able to keep safe the females so that they can exercise their reproductive rights in safe and sound manner. International document relating to reproductive rights. Since it is a known fact that reproductive rights have been categorized under the domain of human rights, therefore, it becomes important that reproductive rights need to be emphasized relatively more than other rights in furtherance of the demand of time and study. Thus, in order to know the working state of a reproductive right in an international world, focus should be on the study of those documents which talk about the importance of the reproductive rights and lay certain guidelines and liabilities to regulate the implementation of the same. Efforts are also made to throw some lights on the effort of the judges of India who with different judgments have tried to cherish, incorporated and imbibe the principle of UNO so as to strengthen the reproductive right of the women in India. These documents are enlisted as follows. Number 1, the Universal Declaration of Human Rights 1948, the International Covenant on Economic, Social and Cultural Rights 1966, the International Covenant on Civil and Political Rights 1966, the International Convention on Elimination of all form of racial discrimination 1969, Convention on the Elimination of all form of discrimination against women 1979, Convention on Right of Child 1989, the International United Nations Conference on Population and Development 1994, Chapter 8 of International Convention on Population and Development Program of Action, Reproductive Right and Reproductive Health 1994. The Constitution of India, guardian of life, dignity and reproductive freedom of women. The highest law of the nation, which aims to protect the life, liberty and dignity of the citizen of India, is the Constitution of India. The ideas inculcating the idea of social, economic and political justice to all the citizens of India, including the females, is highlighted in our preamble. After independence, since the Indian Constitution is the grand norm, so it becomes essential here to discuss those important articles which aim to preserve and secure the life, liberty, dignity and the reproductive freedom of the women. These articles are Article 14. It is among the most crucial articles of the Constitution of India. The term equality before law signifies that no special favor or treatment must be given to any person, while the expression equal protection of law implies ensuring equal treatment to all in equal circumstances. Article 14. Since is meant for all the individuals of a nation, so the females are also included within its purview. The women of India has every right to represent herself before the court of law in case her reproductive liberty get infringed. Article 14 imbibes within its two important legal expressions, that is, equality before law and equal protection of laws. The term equality before law is similar to what Dicey called the rule of law. Rule of law means that no man is above the law and that every person, irrespective of his position, is subject to ordinary law of the land and is amenable to the jurisdiction of the ordinary tribunal. The second expression, equal protection of laws, is corollary to the first expression and is based on the last clause of the first section of the 14th Amendment to the American Constitution. This expression declares that no person should be deprived of equal treatment before law within the territorial jurisdiction of the Union in the enjoyment of his rights and privileges. In other words, it implies to convey all individual need to survive in the society without any favorism or discrimination. Article 15 contains provision for a specific implementation of the ordinary document of equality of treatment embodied in Article 14. Article 15 Clause 2 talks about prohibition of discrimination to public places on basis of certain grounds such as race, caste, sex, birthplace, etc. Article 15 directs that the state shall not discriminate against any citizen on ground only of religion, race, caste, sex, place of birth or any of them. Any law discriminating on one or more on these grounds would be void. The right guaranteed in Article 15 Clause 1 is conferred on a citizen as an individual and is available against his being subject to discrimination in the matter of rights, privileges and immunities pertaining to him as a citizen. However, restriction provided in Article 15 Clause 2 would apply only if the places mentioned in clauses are either maintained wholly or partly out of state funds or dedicated to the use of general public. Attention is drawn to the word only in Clause 1 and 2 of Article 15. That is, the state should not discriminate against any person on ground only of religion, race, caste, sex, place of birth or any of them. It is the effect or operation of the statute which is the determining factor and not its purpose or motive. Accordingly, the court should hold a law repugnant to the guarantee given by Article 15 Clause 1 if, as a result of a law, a person is denied any right or privilege solely because of his religion, race, caste, sex or place of birth. In spite of the fact that Article 15 talks about prohibition of discrimination on the particular grounds, still there are cases where women are discriminated very brutally just because they belong to a poor strata of society. Article 21. This article is considered as one of the most important and crucial, which aims to preserve life, liberty and dignity of human existence. This article is the most dynamic, organic and progressive provisions of our living constitution. In Bandhu Mukti Morcha case versus Union of India, the Supreme Court came out with an observation that directive principles of state policy confer its diligent shadow upon Article 21 of the Indian Constitution in order to enlighten its soul, thereby strengthening it with the power of imparting the right to live with human dignity. Moreover, keeping in view the weight of other provisions of the Indian Constitution, Articles 39, Clause E and F, Article 41 and 42, the Apex Court aims to pass order in support of the subordination of power for effective implementation of these provisions as they deal with the basic and fundamental necessities to be fulfilled for the purpose of leading a worthy life without much prevalence of harsh inconsistencies. It is said so because these provisions are backed by the object of protecting and safeguarding health and capability cum strength of the workers, men, women, children of tender age, and protect them against any kind of physical or mental abuse, lay down opportunities in the field of education and other valuable facilities that need to be introduced in a developing nation, promoting of justice and human conduct in every sector of governance and employed as well, granting of maternity leave within ease, etc. Since law is always in flux and it keeps on changing with the changing condition of the society, so with the passage of time, the judges have given an extended connotation to the right to life. Since Article 21 aims to protect the life, liberty and dignity of women, so all those cases where the judges protected the reproductive freedom of women need to be discussed here. In case of Vishakha and other versus State of Rajasthan and others, the Supreme Court of India observed that sexual violence, apart from being a dehumanizing act, is an unlawful intrusion on the right of privacy and sanctity of a female. It is a serious blow to her supreme honor and offends her self-esteem and dignity. It is a crime against the entire society, a crime against basic human activity. Guidelines with regard to the protection of women at workplace and incidental prevention of sexual harassment against them at a workplace were passed by the Apex Court in this case. Article 23 guarantees the fundamental right against exploitation. Not only the citizens or non-citizens, but the aliens also enjoy this right. Not only the protection operates under the purview of this section against the state or public authority, but it equally goes against the private individuals as well. Therefore, it means that neither the state nor any private individual can infringe anyone's fundamental right or exploit the other. Thus, Article 23 restrains trafficking in human beings. Trafficking of the human being, especially of the women, directly encroach and attack the reproductive freedom of the women because women are trafficked, are physically, mentally and sexually abused. Article 39 Clause E. Not only the fundamental rights but the directive principle of the state policy equally object to preserve the health of the human being. In Senate PV versus State of Kerala, the Kerala High Court, while stressing upon the health of a male and female workers, held that Article 21 of the Indian Constitution enshrines the right to secure health of a worker and is integrated and deep-rooted part of Article 21. Moreover, this provision of the Constitution accounts for the promotion of health and strength of every person and specifically the worker, and for this, the state shall be duty-bound to act in affirmation of the same. Article 42 aims to provide maternity benefit to a pregnant woman in India. The maternity benefit to be availed by the working pregnant women becomes important part of reproductive freedom of women. Hence, it becomes essential for the Government of India to lay down such policies which aim to provide all kind of maternity benefit to the pregnant women. In case of Municipal Corporation of Delhi versus female worker, a claim for grant of maternity benefit on an equal scale to that of the regular worker was made by the union constituted of female workers. These workers were temporarily employed in the factory and therefore, being devoid of employment on regular rules, the claim was made just in a view of furthering their common object. The Supreme Court very clearly held that women workers who are in state of pregnancy in its advanced stage should not be forced to indulge into hard labor activity because it might prove to be harmful for the health of the pregnant women and might also harm the developing fetus. Article 51, Clause A, Subclause E. Apart from the fundamental rights and the directive principle, the fundamental duties also give importance to the life and dignity of the women. Article 51, Clause A, Subclause E aims to shun all those practices which prove derogatory for the female. The provisions under the Indian Penal Code 1860. The various provisions which talk about causing death of the fetus which is growing inside the body of the mother are discussed in the light of section 312 to 318 of the Indian Penal Code 1860. The Indian Penal Code 1860 has always supported the act of giving birth to a child. Hence, all such circumstances where miscarriage is thrust upon the pregnant lady against her will or consent are viewed with suspicion under the said statute and stringent punishments are laid for such kind of acts. The Indian Penal Code 1860 does not mention expressly about the term sex-selective abortion. However, sincere endeavor is made to discuss all the offences committed against the unborn child through the application of provisions mentioned under section 312 to 318 of the said law. Section 312 to 318 of the Indian Penal Code openly deals with such kind of act where the child inside the womb is forcibly killed or where the death of the pregnant lady occurs in pursuance of carrying such activity upon her. Assisted reproductive technology. According to the Center for Disease Control and Prevention, United States, ART include all fertility treatment in which either the egg or the embryos are handled. In general, ART procedures involved surgical removing eggs from a woman's ovary, combining them with the sperm in the laboratory and returning them to the woman's body or donating them to another woman. They do not include treatment in which only the sperms are handled or procedures in which a woman take medicine only to stimulate egg production without the intention of having egg retrieved. The ART services are used across the world to treat infertility. Under this process, the eggs are removed from the body of a female and then are mixed with the sperm to make embryo. This is done in a clinically environment in laboratories under the supervision of a medical expert. The embryos are then put back into the body of women. The donor eggs, the donor sperm or previously frozen embryos are used in ART procedure. ART techniques are sometimes used in surrogacy arrangement, but not all surrogacy arrangement include ART techniques in it. Maternity Benefit Act 1961 and the reproductive rights. Motherhood is always regarded as the essence of female and she is considered as the blessed soul who is given power and authority by God to give birth to the future generation. In a civilized society, it becomes essential to establish such parameters, rules and regulations which act as a support system for the female who is about to give birth to a child. Keeping in mind this view, it becomes obligatory here to understand as to how the Maternity Benefit Act 1961 helps in protection and exercise of the reproductive rights of the female. The points relating to it are discussed as follows. The female who is pregnant with the child need to cater to the needs of the child which is developing inside her womb. The Maternity Benefit Act 1961 recognizes the very basic characteristics of motherhood and paves the way for striking the balance between the motherhood and the work of working women. Reproductive rights not only revolve around the pregnant female but also include in it the prenatal and the postnatal care so that the child while being inside the womb and after his or her birth is taken care of in a proper manner. Provision of granting maternity leave to the pregnant women caters to such need and eases down with the period of and after the pregnancy to the female. Introduction of crèche facility by way of Maternity Amendment Act 2017 further tries to help the women to have given birth to a child but otherwise are single parent or have no option to leave the child at home alone since family is not living with the child. This further support motherhood and help in establishing the right to have a family in practical, legal and justified manner. Last but not the least, the provision of work from home has enabled the complicated cases of pregnancy or post-pregnancy of a woman to strike a balance between the work and the newborn baby. Sometimes after the birth of the child and after consuming the maternity leave, still certain health issues persist among the female that they are not able to travel and work in an organization, or in majority of cases due to weak immune system, the female are asked to opt bed rest for few more months after the delivery of the child. In all these circumstances, the option of the work from home gives a fair chance to the female to look after her health of the child and work from home, thereby not causing any adverse effect upon the establishment. So it can be concluded by saying that the constant fight for the recognition and realization of the reproductive rights is still going on in every corner of the world. The establishment of the reproductive rights directly depends upon the women empowerment, which includes the contribution of women to create just, reasonable and fair social and economic order. Reproductive rights are human rights which aim to save the lives of the women by protecting them against torture, exploitation and discrimination once they come in connection with the male patriarchal society. Through the Constitution of India is the guardian of reproductive rights of women, yet need of the hour is to widen the scope of reproductive right with the help of Article 21 of the Constitution of India. Many people are still not aware about the legal, social and ethical implications involved in the process of availing the benefit of assisted reproductive technologies. Hence, the need of present time is to eradicate such void and establish complete comprehensive system, thereby strengthening the reproductive rights of human beings in India. I hope this lecture is useful for you. Thank you and have a nice day.